Good morning, good afternoon, good evening, ladies and gentlemen. My name is John McKenzie, and on behalf of Baker & McKenzie and our Global International Trade Commercial Practice Group, it is my great pleasure to thank you for joining us and welcoming you to our mid-year trade conference for this year, 2020. Over the course of the next 2 days, we will now run 6 sessions discussing key trade developments over the last 12 months. As you can see from the screen in front of you, the first session that we're about to launch into will focus on export control developments in the US, the UK, and the European Union. Later in the course of the day, we'll talk about customs and import developments, US, Canada, Mexico, and the EU. And then to conclude today's program, we'll talk about trade developments from a China perspective, China import and export issues that may affect your business operations. Tomorrow, we'll shift our focus and start the day by talking about the whole panoply of sanctions directed at Russia, and follow that with a session on Russian countermeasures or counter sanctions. And then to conclude our program at the end of the day tomorrow, we'll talk about enforcement developments under these export sanctions and customs rules. So I certainly hope that you will all be able to join us for as many of those sessions as possible. And I should say that it's our endeavor to make this program as useful and beneficial to all of you as we possibly can. To that end, preparatory to the program yesterday afternoon, our team did distribute copies of all of the slides and PowerPoint materials that we'll be going through in the course of the next several sessions. If you did not receive them, please just indicate in the Q&A session that you need the materials, and we'll make sure that we get them to you. The sessions are being recorded, and therefore, if you or your teams would like to get recordings of the programs, please again let us know, and we'll make those materials available to you following the conclusion of the sessions. The program has been approved for continuing legal education under CLE, CPE, CCS, and so forth. And so for those of you who need continuing legal education, the communication that we sent out yesterday includes a sign-up sheet for requesting that CLE credit, and please return that and send it to us within 72 hours of concluding the session so we can get you your CLE or other continuing legal education sessions. Also, in furtherance of our effort to make this as useful as possible to all of you, please do not be shy about interjecting questions at the end using the Q&A button on your screen. At the end of each session, if our time permits, we will take as many of the questions as we can and attempt to address them. If time is limited and we cannot address all of your questions, or if questions may involve some concerns about confidentiality, please indicate in the question and we will respond to those questions by email following the sessions. I hope you will indulge us. At least some of our colleagues are presenting and sharing their expertise on these topics with us remotely from home, so there could be the possibility of a dog barking, a doorbell ringing, or a landscaper out there with one of those hideous blowing machines. But please do indulge us. So with all of that, by way of background, it's my great pleasure then to introduce this first topic, our export control program. To take us through the materials that we've prepared, with my great pleasure and privilege to introduce to you my colleagues who very kindly agreed to share their expertise on these topics with us during the course of the sessions. First, let me introduce Allison Stafford Powell, one of the partners from our Baker McKenzie office in Palo Alto, who will lead and moderate this session. Joining Allison are Carrie Contini, a partner from our Washington office, Alex Lamy, a partner from our Washington office, Ben Smith, a partner from our London office, and Paul Amberg, a partner from our Madrid office. So that's our cast of characters for today's session. And let me now please turn it over to Allison. And Allison, if you would lead us through the topics. Thank you.
Thanks very much, John, and good morning, good afternoon, good evening, everyone. So we've got quite a lot to cover today. We'll kick off with emerging and foundational technologies and cybersecurity controls. So it's been a little while now since the passing of the Export Control Reform Act in 2018 that mandated a review and identification of emerging and foundational technologies warranting control. But Alex, perhaps you can bring us up to date on what has happened so far. What's the latest on and what may we see coming next?
Sounds good, Alison. Thanks. Thanks everybody for joining us today. So just to start off, this process about the emerging and foundational technologies is continuing within BIS, and they're working on these different issues, but I think they are sort of maturing their process about how they're thinking through these issues, which we'll touch on today. So to take you back to 2018, after the statute was enacted that Allison mentioned, BIS first got out of the gate with a request for public comment about what types of emerging technologies should be controlled and what the agency should consider in doing that. And they received a lot of comments in response to that request. And since then, BIS has been moving forward with their process of primarily seeking public comments about ideas that they want to, different ideas about different technologies they want to control, and then going through primarily the multilateral process in order to impose those controls. On this slide, we've identified the 4 most recent proposals and different implementations of the emerging technology controls that BIS has implemented, with the most recent ones coming out in May, where BIS proposed imposing controls on 4 marine toxins that, given that there's been some developments in how they can be extracted and deployed, that BIS considers them to likely be a good candidate for emerging technology controls. So I think we're going to continue to be seeing that process continue. On the other side, with the foundational technology developments, BIS certainly took longer before to get around to starting the process of trying to get public comments about what should be considered foundational technologies and what should be controlled. And what was sort of interesting, if you look at the August 2020 notice that BIS issued soliciting comments about what could be foundational technologies, they took a very different approach to what they did with emerging technologies, where they didn't identify specific categories. I think they learned that they perhaps didn't want to be limited in that way. They really wanted to have a broad scope of soliciting comment from the public and industry about what should be controlled. And then what we've seen, what's sort of been interesting this year is what BIS announced in May when they requested or published a rule about the 4 marine toxins, is that they said that they're no longer going to try to make a distinction between emerging technology or foundational technology. They're now going to be called Section 1758 technologies, which refers back to the provision in the ECRA. And BIS's logic for this is that it's going to be more efficient for them, because as they were going through these processes of trying to determine which one falls into which category, that was slowing them down, and they'll be able to act a little more quickly on trying to implement controls on these types of technologies. And BIS, their view is also that it can be hard to make a distinction between these 2 categories of controls, and the ECRA does not require BIS to do so. One example they provide is that you could have a technology that could be considered foundational because it constitutes an iterative improvement on existing technology, but at the same time it could still be emerging because no company has actually put it into production yet. It might still be in the development stage. So from their perspective, they didn't really see a point in making those distinctions. And I think most importantly, from BIS's perspective, from a controls perspective, there's no difference whether how it applies within the AR context or also in the CFIUS context in terms of constituting critical technologies. So for all those different reasons, BIS is no longer going to make those distinctions. So we're never going to see a foundational technology public notice. It's all going to be considered a Section 1758 technology going forward. In terms of how they're implementing this, BIS officials had some interesting comments at the update conference that they just held right before the 4th of July holiday, where they made comments that were sort of consistent with what they've been doing so far. But first point is that they're going to continue their approach of proposing ECCNs that will end up on the Commerce Control List. There's not going to be a separate provision in, for example, Part 742 of the EAR. These are just going to be products or items that may be controlled through the normal way. I think the other main point is that BIS really remains committed to the multilateral approach to implement controls on the Section 1758 technologies, which is consistent with what industry has always advocated and trying to have a level playing field on these types of controls. Now, certainly this continues to be criticized by Congress, pushing BIS to act more quickly and potentially use more unilateral controls, which BIS is willing to do and does do occasionally, but I think certainly their preference continues to be their multilateral approach. And then the last point I'll make about these developments is, again, at the BIS conference, the update conference, there was a very interesting speech by the National Director of Intelligence, who made it very clear that this is a keen interest for the government, even in the intelligence context, that this is something that they are monitoring very closely and that they want to collaborate more closely with BIS and perhaps improve their intelligence capabilities to be more responsive to these kinds of issues. So I think that certainly shows how important this is for policymakers within the administration, even if Congress believes they could be more proactive and be implementing more controls. So with that, if we can turn to the next slide, just to turn over to the cybersecurity controls and go to the next slide. So this started actually last year in October when BIS issued an interim final rule where they proposed new controls on cybersecurity items. And this is really considered to be a successful reboot of the cybersecurity controls that BIS tried to propose in 2015. It was criticized by lots of different parties in industry and policymakers that the approach they took could be really damaging to ensuring cybersecurity. And so BIS really went back to the drawing board and went back to the Wassenaar arrangement. And since that time, they've been working on that process. And I believe it was in 2018 that the Wassenaar arrangement came up with a new proposal, and that finally came out in the rule that was published in October of last year. So the main things that BIS did through these new rules is they implemented new ECCNs for cybersecurity items that are found in Category 4 and Category 5, Part 1, that are identified here that could be used for malicious cyber activities. And we've identified the ECCNs here. And then in conjunction with that, while imposing these controls, BIS also issued or published a new license exception called Authorized Cybersecurity Exports, or ACE. And this has the controls or limitations that you might expect that these products and items cannot be sent to embargoed countries. And then there are some favorable treatments for certain types of cybersecurity end users, because BIS, I think, is now really cognizant that they want to make sure that these are not used for malicious purposes, but they also understand they can have very important purposes for cybersecurity and ensuring that networks can protect themselves. And so there's different categories of companies and institutions that can have access to these kinds of items under license exception ACE. And there are different restrictions, on the other hand, on certain types of government end users, especially if they're in country group D, with a few exceptions, and then also some non-governmental end users are in country groups D1 or D5. The other interesting aspect of license exception ACE is that it does have an end use restriction, that even if you are providing these products or these items to an authorized party, you do have to be careful that you don't go forward if you have knowledge that it could be used for malicious activities with respect to an information system. So it's an interesting combination of those two kinds of controls within the license exception. And so initially this rule was going to take effect in January, but in part in response to the various public comments that BIS received, they pushed that back to March. And then if we can go to the next slide, the most recent development for the cybersecurity rule is that in May, BIS finalized the rules, and then in response to the feedback they received, they made two primary changes to this scheme. Is that first, they made some updates to license exception ACE by providing more guidance about which government end users are going to be targeted and what the restrictions are for them. There was lots of comments that the scope of government end users was ill-defined, and so BIS responded to that. They also narrowed some of the exports for some countries, some parties in country group D. And then they, based on the feedback, they also decided to make changes to license exception E and C, where there was a concern that if you integrated encryption functions into a product that would be a cybersecurity item, you may be able to export or re-export it pursuant to license exception E and C, even though it wouldn't be permitted under license exception ACE. So what BIS did is they added a new end user restriction for certain types of ECCNs that are identified on the slide. If you are aware that it could affect confidentiality, integrity, or availability of information systems. So BIS is trying to make those consistent. And then the last point from that notice from May is that BIS said they're going to issue more guidance about these different controls. They did issue some in November of last year, but they do plan to issue more guidance in response to the comments that were received. So that's the summary of those developments. I'll turn it over to Paul now.
Hi, everyone. Thanks, Alex. Pleasure to be with you here today from hot Europe. Today, I'm going to kind of go through various topics touching on China-related U.S. export control developments. So we have a bit of ground to cover, but I hope that we hit on a lot of the key issues in this regard. And if not, hopefully you have some time to do some Q&A when the session is over. We've had some good insights into how BIS is viewing its China-related policy in recent weeks, in fact, because given that the Undersecretary for Commerce for Industry and Security, Alan Esteves, was confirmed in April, there have been several instances over the past couple of weeks in which he has given testimony to provide Congress with some information on the enforcement efforts, on where BIS is with respect to certain industries, with respect to these emerging and foundational technologies that Alex was discussing, and indeed in respect of the entity list and why, in the eyes of certain congresspersons, there's not a faster pace of designations of Chinese parties in particular on the entity list. And it's not as if we don't have a lot. One of the things that testimony elucidated was that we currently have around 600 Chinese parties designated. And as we saw as recently as June of this year, another swath of Chinese parties was designated. And we have ever expanding listings of Chinese parties on the entity list. Of course, China is not the only country that's targeted by this, with Russia and Belarus recently being also a target, but that will be covered in separate sessions. And I think this sort of has a few implications for all of you. I mean, it's obvious that with higher volume of parties, the greater the burden on your due diligence processes to capture potential transactions with entity list parties. I was thinking that it's kind of a good thing, and hopefully I don't swear this into existence by making this comment, but that we don't have an OFAC 50% rule in the context of an entity list, because if we were to move towards that, the compliance burden would multiply by quite a bit. So at least in this context, we're focused on common challenges that we'll get into a little bit of, are we dealing with an entity list party based on available information? What does our screening reveal? And then how do I approach licensing when I do identify a transaction that involves an entity list party? And the reason why this is important is that not only the congressional pressure of focus on BIS and really putting a fire under them to enforce the EAR, in particular with respect to China, but also we have a track record already, as we can see by the three recent cases, or relatively recent cases, that are summarized here, of parties who had to pay civil administrative penalties to settle EAR violations in respect of dealings, in most cases, of EAR 99 items only, with parties listed on the entity list, including Huawei. So we have the track record of enforcement already starting following the 2019 designation of Huawei. In addition, not mentioned here, and anecdotally and in experience, any number of clients have received administrative subpoenas discussing or inquiring as to dealings with entity-less parties such as Huawei, among others. So it's not solely a matter of potential violations of the EAR and voluntary self-disclosures and related enforcement actions by OEE, but also administrative subpoenas requesting information and documentation. So that turns us to sort of the common challenges. I mean, this is not particularly new to the past 12 calendar months, but I just think that we've seen such an explosion of listings of Chinese parties on the entity list that we have now seen a few key common challenges emerge in the context of assessing your compliance obligations where there might be an entity list party involved. So the number one is just that the issue of affiliates, right? It's, the BIS guidance talks a lot about, it has to be a legally distinct affiliate, distinct from the entity listed party in order not to be the entity on the entity list. So that gets into questions of, well, whether it's a branch, whether it's a separately incorporated entity, how closely do the address matches? And even if it is a separate entity, what sorts of safeguards do I need to implement to make sure that I'm sure? Whether it's certifications, whether it's, concern that an affiliate is acting on behalf of an entity listed party. There's never a perfect solution to these, and oftentimes it's going to be a risk-based call. But if you try to request informal guidance, I think many times, BIS will really just ask you to look at the FAQs and won't really provide too much insight other than that. So it really comes down to evaluating the risk of a situation and making a risk-based call as to whether the transaction implicates an entity list party. The other common challenge is one of screening, the eternal challenge of sort of how, in the context of China, we go about screening for entity list parties and other restricted parties. And here there's obviously a few sub-challenges, including the issue of translation, where we are translating to Pinyin versus translating to English. Do we have to verify circumstances where we have incomplete address information? If there are different or inconsistent translations of names, for example. And I think an absolute belt and suspenders approach is sort of this reverse translation approach as well. But we've only really seen that in the context where you're trying to sort of prove that a violative transaction didn't happen in the context of an enforcement action, and not so much as a best practice day-to-day screening process. I think the most important thing on the translation point is just to have a consistent methodology for how you undertake that, and a consistent translation for terms from Mandarin to English. The licensing point is one that, I just want to comment on a few trends we've seen recently, in particular since the Undersecretary has been confirmed and there's been a renewed pressure from Congress on licensing, the amount of license to Huawei and other entity list parties that have been granted. We have seen an increase in scrutiny for any license implicated in an entity list party, including several rounds of follow-up questions in many cases, a sort of renewed interest, and even where it's low-level technology, EAR 99 items, really those processes are becoming very long when they involve an entity list party. I'm sure you have all had similar experiences, detailed follow-up questions. So it's just sort of indicative of a trend that there will only be increasing scrutiny on any license application involving entity list parties, and with a higher volume of parties now on the list, the burden on folks applying for licenses will only increase. So the key there is really to have a methodology set up so that you're prepared to promptly and efficiently respond to follow-up questions or address those upfront in any license application. Next slide, please. So switching gears, hopefully not too abruptly, but one of the ongoing challenges we have under the EAR, and especially as it affects China and entity list parties, but not only China, are these FDP rules under the EAR. And BIS back in February of this year helpfully consolidated some of the rules that were scattered throughout the EAR into 734.9 of the EAR to lay them all out in a row. So right now, just by way of reminder, there are 6 different types of foreign direct product rules under the EAR. We have the original rule that relates to items that are the direct product of national security control technology or software. We have the 9X515 and 600 series FDP, which focus on control of exports caught by the rules to country groups D and E. We have the so-called entity-less FDP, which used to be located in another provision of the EAR and not really consolidated in the same form. Right now, as you all know, that focus is solely on Huawei, but the consolidation, I think, meant that there's the potential that in the future, as we have more entity listings, and this is one of the areas that I think Congress would be interested in seeing more development on, the fact more parties being subject to this entity-less FDP, in particular, as we see Chinese parties continue to supply Russia in the light of the Russia-Ukraine war, for example. And then the Russia-Belarus FDP, and then the Russia-Belarus military end user FDP as well. We won't go into those two since the focus of this is on China, but I just wanted to lay those out because it's sometimes really helpful to have in your head the myriad FDP rules that are now set out in section 734.9 of the EAR. Now, the good news is that when you're reviewing these rules, they all tend to follow a similar order of review in terms of the prongs you have to look at. So it's the product scope, is the product in scope, right? Either because it's the direct product of the captured technology or software, or it's the direct product of a plant or major component of a plant that is itself the direct product of such technology. That's always a mouthful, right? And then the second aspect of this is, is it within the destination scope of the rule or the end user scope? And as you know, I mean, obviously, because of the 6 different rules, they're either destination based or end user based in the case of the military end user and the entity list FDPs. There are some common issues. I mean, and they're perennial issues. When is something a direct product, right? It's a pretty expansive definition of it's the immediate product, including process and services produced directly by the use of the technology or software. So usually it's pretty easy to meet that test. Is the technology or software in scope? This varies across the rules. So you have to very carefully read the rules to see whether the particular rule covers just US origin technology or whether it also covers all technology subject to the EAR, right? So these vary across the different rules. And so it requires a very close reading as to whether you're only concerned about things that are the direct product of US origin technology or software or anything subject to the EAR. When do you have knowledge or reason to know? Recall the very broad definition of knowledge in the EAR of not only positive knowledge, but the awareness of a high probability of a fact's existence or future occurrence, which in itself can be inferred from what we call a conscious disregard of facts. And one of the examples as we sort of move to the next slide, Anna, this graphic you've seen at other of our conferences, I've kind of layered on the product scope and end user scope sort of headers there so we can clearly divide those two aspects of the analysis. But as you see, I was just talking about in the product scope, in the first prong here, it talks about certain technology and software subject to the EAR, but when we're talking about major components of plants, it's only US origin technology or software and not all technology subject to the, in the context of technology. But then when you talk about software, it's any software subject to the EAR. So the bottom line is that these require a careful reading to make sure that not only the product scope and end user scope is met, but that you have knowledge in addition. So one thing I'd like to highlight here on this slide as we just spend a minute here is just that, this implicates broad due diligence requirements, especially in light of some of the entity lists, for example, FDP FAQs that BIS has published. Most recently, the sort of one question 4 on the supply chain section really zeroed in on, although FDP controlled content is not counted for de minimis purposes under the EAR, if you have a higher level assembly where that your supplier's component is captured by the FDP, well, either you have to get a license if it involves Huawei, or they have to have gotten a license. And so it's not a free pass. There's no sort of a second incorporation type rule in those kinds of scenarios, as we see under some of the de minimis rules under the EAR. So I think that one of the challenges is that because the end user scope here is quite broad, that incorporation point in particular, there's going to be circumstances where you are going to be held to a standard of, you could be viewed as having a conscious disregard of the facts and therefore have knowledge to the extent you didn't make the right inquiries and do the right due diligence. So I just wanted to highlight that as one example in the interest of time under the entity list FDP rule in particular. Now, switching gears, but because it relates to an industry that is hugely affected by a lot of these rules, if we move to the next slide, I wanted to just highlight some developments in the past year affecting the semiconductor industry under US export controls. Now, obviously, this isn't among the most active areas when it comes to China, given the interest that the countries that have developed SME technologies, the US, Japan, Netherlands, for example, Korea, have in sort of preventing access by China to certain cutting edge and other semiconductor related technologies and equipment. So I think that as we saw in Undersecretary Esteves' testimony, he has confirmed that, since he's joined, they are undergoing, BIS is undergoing a full review of their policies. Now, where that will lead, well, I can imagine it will only lead to one place, which is an increase in control and increase in scrutiny on the types of items that are going to be either prohibited to export to China or increasing scrutiny in the licensing scenario of those policies. Number two, I alluded to this earlier, is the congressional scrutiny. And this is coming not only for this industry, but in particular, it's to this industry. But it's a real focus on, what technology nodes are we controlling when we have a licensing policy? Should we lower those to 14 or 16 as opposed to 10? Shouldn't we be listing more Chinese companies in this sector on the entity list directly, or issuing denial orders, or engaging in broader efforts to control from that end the access to those parties of US or other technology from Japan, Korea, or the Netherlands, for example. Behind the scenes, as we get to the third point here, there have been a ton of discussions between the US, the Netherlands, Japan, Korea on a government-to-government basis. And the frustrating thing is that they haven't made any proposals public, but we're aware that they are floating ideas on how to control, in particular, SME and 3B001 or 3B991 in a higher way. And as a part of that effort, of course, each individual government is obviously talking to industry associations, it's talking to companies in the sector about the impact of those kinds of controls. So I think it's, as you all are, those of you who are in the sector, important to be quite closely involved in those processes, because this is really a talk about a new type of perhaps multilateral export control regime focused on this sector, not exclusively, also focusing on AI and things like that, but heavily infecting the semiconductor industry. So, and that'll be separate from Wassenaar. In terms of Wassenaar itself, I mean, there's always ongoing proposals from Wassenaar participating states of increases in controls on semiconductor manufacturing equipment and other semiconductor related items. And we're aware that there are Wassenaar proposals that implicate higher levels of control on this kind of equipment that have been circulated. So I think it's coming from all fronts. So don't forget that at the Wassenaar level, though more challenging in the context of, for example, Russia being a Wassenaar member, and then probably a difficulty there to get sort of changes implemented through that. And I think that's kind of what's driving, in part, these efforts at a separate multilateral regime. So next slide, and I'll close. On the Biden administration China export policy, I mean, you all have been following this very closely, and my colleague Carrie, as I turn it over to her in a minute, is going to touch on some additional efforts here. Just to set the stage, I mean, export controls is a key tool, but it's not just stuff subject to the EAR, et cetera. It's not just about sensitive technologies. It's about listing parties on the entity list to accomplish other foreign policy goals like human rights, corruption, et cetera. So it's a key tool, not just in the context of the EAR. The Biden administration has added 107 parties itself, as Undersecretary Estevez testified, to the entity list. So it's not just a Trump thing, it's really continued to pace under Biden. The enforcement focus is on China. Some of the stats that he shared with the Senate Banking Committee was that, something like a quarter of all existing OE investigations involve China. 66% of criminal enforcement in FY21 was China related, and 40% of civil enforcement was China related in FY21. So clearly that's going to continue. Alex mentioned the Section 1758 technologies. Clearly, as we decide what to control under the ECRA and under that provision, China is going to be looming large in any decision as to what to control. And with that, I think because this last one touches Carrie a little bit on some of the multilateral efforts, I'll turn that one over to you to talk about some of those efforts. Thank you.
Sure. Thanks, Paul. Yeah, let's go to this next slide. So picking up on a few of the points that Alex and Paul commented on, I mean, we're clearly seeing a trend of more export controls targeting a whole range of different issues, things like emerging technologies, semiconductors, a lot of focus on China and Russia. So I was looking at this from a slightly different perspective, which is just looking ahead. What is on the horizon? What do we expect to see going forward? And really, in short, I think we really do expect to see a continuation of these trends, not just through standard regulatory processes, but through some other initiatives. And as Paul mentioned, I wanted to discuss just for a few minutes some of the Biden administration's initiatives around multilateral controls, and then also some of Congress's initiatives and bills related to export controls. We're really seeing continued involvement at the congressional level in export controls related legislation. So on multilateral controls, I think both Alex and Paul mentioned this briefly. This is something that we've been seeing a trend towards multilateral controls for a couple of years now, but this is really picking up and becoming, not just a peripheral idea or something that's a nice to have on the side of other initiatives, but really a big part of the Biden administration's export control strategies. And this matters. This is not just an academic discussion. It's interesting, but it's not just interesting, right? It matters because it can result in more items being controlled in more places around the world, not just the US, but the other countries and jurisdictions that would be collaborating with the US on these issues. One initiative that has been getting a lot of attention is the one that Paul briefly mentioned. There's been a lot of talk in recent months, starting this spring, I think it was around May, of a possible new regime that would sit alongside Bostoner and the Australia group. So on this slide, I just listed some of what we usually think of as the main multilateral export control regimes, which cover different sort of buckets of controlled products. So, chemical and biological weapons, items that are controlled for nuclear, non-proliferation reasons, missile technology, and other dual use controls that are under the broad Bostoner controls. All these different regimes have slightly different combinations of members. And we've been hearing about a possible new regime. And really there are several drivers for this. It would become a vehicle to control more emerging technologies on a broader and more multilateral basis, including new technologies, but also semiconductors and related emerging technology issues. Also, this has been seen as possibly one way to put more controls on China, and from the US administration's perspective, to stop sensitive technology from going to China's civil military fusion programs. And in light of the Russia invasion, there has been a growing concern expressed in the US administration and others about Russia's role in some of these existing regimes that you see on the slide. The concern has been expressed that perhaps Russia would not be willing to control things that should be controlled. And as part of that, there has been an effort to capitalize on the unprecedented amount of multilateral cooperation that we did see coming out of the last several months after the Russian invasion of Ukraine. So the ideas that we've been hearing is that this new regime would include US allies, which could include countries like the members of the G7, or the countries and allies that are listed in country groups A5 and A6 in the EAR. So countries like Canada, Australia, the UK, and other close allies. And the idea behind implementing these controls multilaterally is that it would be more effective than unilateral controls. More countries and jurisdictions would have similar controls. And then from a US perspective, there has been concerns raised by industry, by the administration, by a lot of different stakeholders that unilateral controls come with a potential risk of hurting competitiveness of US companies, particularly in situations where foreign suppliers also supply the technology that the US wants to control. So the Undersecretary of BIS, Estevez, has said that this is one of his top priorities. And that the idea would be to start with dual use technologies, focusing on things like technologies that might be at risk of being used for human rights abuses, such as surveillance tools, and then going from there. It could expand beyond those sort of initial high priority technologies. Another BIS official recently said that it's premature to delve into this, that a lot of the details still need to be ironed out, early days of these discussions. But either way, no matter how you look at it, more cooperation between countries and jurisdictions is likely. And one way or another, we're likely to see more multilateral efforts. There are some other avenues for export cooperation at a multilateral level that might overlap a bit with some of the multilateral initiatives I've just discussed. So we'll have to wait to see how everything ends up coming together. For example, there is a US-EU Trade and Technology Council, and that is likely to be leveraged for more multilateral controls by the US and EU, and then possibly expand there to others. And the Commerce Secretary said that the hope is to make progress around this sometime this fall. The Biden administration has been focusing on which US and EU technologies are particularly significant and would warrant this level of additional controls. And going back to Paul's comments, semiconductor equipment and related technologies for semiconductors and chips are identified as a high priority. BIS officials have also indicated that this EU-US Trade and Technology Council could be leveraged for broader sharing of information to better align licensing decisions. There has been acknowledgement that this would come with some guardrails for license applications, which often contain confidential business information, but jurisdictions could share technology trends and users of concerns and perhaps collaborate more on licensing decisions. The final multilateral initiative I wanted to mention is something that the Biden administration announced in December of 2021 at the US Virtual Summit for Democracy, and that is a human rights related export controls initiative. The stated objective there was to curb the proliferation of dual use technologies that are used for human rights abuses or at risk of being used in that way. And the US would work with allies to determine how export controls could better monitor and restrict sensitive technologies that could be at risk of being used for human rights abuses. One of the initiatives that was announced as part of that was developing a voluntary code of conduct for how countries would review license applications, with, again, progress intended to be made by the end of this year. So all of these different multilateral initiatives are getting a lot of focus by the Biden administration. And again, we'll have to kind of see how it all coalesces, but it's clear that we're seeing more focus on how the US can work with multilateral regimes, existing, new, or some combination thereof, to expand controls and collaborate more. Let's go to the next slide. I wanted to just briefly touch on some trends we're seeing in some current bills in the US Congress. There have been a number of recent, quite unique export control related measures in pending legislation in the Congress. And as of right now, there's really a small window to advance these measures before the August recess. After that, Congress is going to be focused on funding the government to avoid a shutdown, and then focusing on campaigning for the upcoming elections this fall. But there are some limited export control measures in two bills that are likely to pass. One is the National Defense Authorization Act, which is always known as a must-pass legislation, really need that legislation to pass one way or another, and often becomes a vehicle for a lot of different measures. And then also the United States Innovation and Competition Act, also known as the CHIPS Act, which is focused on increasing the competitiveness of the US semiconductor industry. We're also seeing some standalone export controls bills, which at this point in the congressional year probably won't advance during this Congress, but they provide a sense of the focus that Congress has been giving on export controls and what we might see down the line. So taking all of the different bills into consideration, we're seeing some key themes emerge, and they're very similar to the kinds of themes that Paul and Alex mentioned have been a focus of recent US export controls measures. So a lot of focus on China, that's sort of overarching and overlaps a lot with a lot of these other themes. Measures related to using export controls for human rights reasons, to address concerns related to IP theft, data privacy, tech transfer, and kind of honing in and strengthening the various export control blacklists, like the entity list and measures like denial orders, the efforts to try to make those a bit stronger from Congress's perspective. Just a few points on some specific pieces of legislation. The NDAA, as I mentioned, this is known as a must-pass piece of legislation. The version that passed the House last Thursday has gone through its second amendment process, and that did include a few export control related provisions. They're pretty specific, so they include things like extending restrictions on exports to the Hong Kong police force, requiring presidential notifications for certain exports of defense articles. There really weren't a whole lot of export control measures in that bill, but there were a lot of provisions focused on sanctions and Russia and other things that will be addressed in a separate session. It is interesting that a lot of the export control measures in this bill and some of the others have been pushed more by Republicans. So there might not be as much bipartisan agreement behind some of these measures, but we are seeing at least some bipartisan agreement on some of the more conceptual measures, like using export controls for human rights related reasons. The Senate version of the NDAA has not yet gone through the amendment process, but we are watching to see if that includes additional measures. I also mentioned briefly the CHIPS Act. This is a much broader bill that includes a range of measures and takes a carrot and stick approach to improving competitiveness of the US semiconductor industry. The House version is further along. The Senate version was essentially stalled until yesterday due to disagreements between the Democrats and Republicans on budget reconciliation issues. But Biden announced that he supported both the Senate and House version here. And these bills include a very heavy emphasis on the carrots. So the incentives to improve the competitiveness of the semiconductor industry, like some incentives worth up to $100 billion, investment in R&D, not just for semiconductor, in fact, but also other emerging technologies like AI, quantum computing, biotech, and others. And there were some what I would refer to as the sticks. These are the export control provisions that try to address US competitiveness in a different way. The House version included a few provisions. Again, another one stating that it's US policy to use export controls to protect human rights. The Senate version has some statements on export control policies and ties some of the incentives to export controls by saying that they are not available to entities of concern, which includes parties on the entity list. So this is all part of the broader environment where, although there is some disagreement between specific measures, there is kind of general agreement on using export controls to seek to address Congress's concerns related to China, human rights, and things of that nature. There are some other interesting bills. I'll just mention one. There is a bill called Protecting Americans' Data from Foreign Surveillance Act. This one is, I find it to be particularly interesting because it would use export controls to address concerns related to personal data and data privacy. There doesn't seem to be enough time for this to pass as a standalone measure, but it does have bipartisan support. So it's possible that we'll see this offered up as an amendment to, for example, the NDAA or some other measure. And we may see it again, if not in this Congress, in the next Congress. And this would require Commerce to work with other agencies to identify categories of personal data that, if exported, could harm national security. It would require licenses for all but the most low-risk countries and would establish a presumption of denial. And in determining the risk status of countries, it would look at a range of factors such as the country's export control laws, whether the country would essentially require someone in that country to disclose personal data, whether the country has conducted hostile foreign intelligence operations against the US. So lots going on in Congress. We'll continue to see that in this Congress and likely the next one too. I'll hand it over to Allison now.
Thanks very much, Kerry, Paul, and Alex. Just before we switch over to the other side of the pond, can I quickly ask Paul to address one of the questions in the chat to clarify how the entity list prohibitions apply to US content versus US persons? And can you export to an entity list party from outside the US, or is the prohibition on the receipt or import of items from entity list parties?
Thanks, Allison. Yeah, happy to quickly address that. So the focus is on the baseline question of whether the EAR applies, right? And if so, then that triggers a prohibition on the export, re-export, or in-country transfer to the entity list party, depending on the level of control on the entity list. So it can be the case that a non-US item, right, that contains US origin content, as is in the question, could be subject to the EAR if that content is controlled for the country in question, say China, and it exceeds a de minimis amount for that country, which is 25%. One point there is just that, you know, the de minimis amount is determined by the destination country, not the end user involved. So don't get confused that just because there are higher restrictions on the end user, that doesn't mean that somehow the de minimis rules or methodology change. So it's not really focused on the import per se of content or items from those parties. In fact, BIS has issued FAQs which clarify that those are not among the prohibited transactions, really about focused on outbound transactions of items subject to the EAR with entity list parties.
Great, thanks very much, Paul. Right, so kicking it over to the UK, Ben, in the sweltering heat over there, what's been going on in terms of UK export control developments post-Brexit?
Yeah, thanks, Alison, and hi to everyone. So we're going to a brief recap on or overview of the UK and then EU export control framework. And it's fair to say that the developments in the last 6 months or so have been more incremental. We did have some major developments last year in the last 18 months, Brexit being one of them, and then we'll talk about the recast EU dual use regulation. But it's fair to say that most exporters and also authorities and legislators have been very focused on Russia in recent months. And there's some significant overlaps between the Russia sanctions and the export regime that we'll get into in the sessions tomorrow. In terms of those UK developments, so winding back in a bit of a recap, so over 18 months ago now, we had the impact from Brexit on the UK's dual use framework. So previously, the UK was part of the pan-EU export control framework in respect of dual use items under the dual use regulation. But then as of effectively the 1st of January 2021, the UK went alone and had a standalone export control regime, same for sanctions as well. As of that date, the UK transposed the then existing dual use regulation into its law. And then later in that year, the EU, and we'll talk about this in a slide or two's time, the EU then updated its dual use framework, the much anticipated recast regulation. So immediately we have a bit of a divergence between the UK dual use export control framework on the one hand, and then the EU export control framework. Within that, given the special position of Northern Ireland and the protocol on Ireland and Northern Ireland, at the moment, Northern Ireland is subject to the new EU rules. There are some questions, and there's obviously a bit of turmoil within the UK government at the moment with the change in Prime Minister. There's some question marks over the relevant Brexit protocol and where that may be headed going forwards. But for now, we have separate EU and UK dual use regimes, with Northern Ireland still applying effectively the new updated EU controls. One of the big questions is whether the UK would follow those material enhancements of the EU regime. I'll come to some incremental developments in a slide or two's time, but we're still awaiting whether the UK will adopt certain elements of the enhanced EU dual use framework for Great Britain. So much more focus on cyber surveillance and human rights, as the US team had talked about. We've seen similar developments in the EU. We're still waiting as to what the UK may do on that front. Beyond that, I mean, the team talked about emerging and foundational technologies and a focus on the tech sector, focus on cyber surveillance. One area we are seeing a great focus there is in terms of foreign investment. So the UK has a new framework, the National Security and Investment Act, where dual use does play a big role. So in terms of inward investments, in terms of certain asset transfers, there are questions around access overseas to UK dual use technologies and certain UK technologies of sensitive national security perspective. So we're starting to see a bit of a focus through the foreign investment framework on export controls, and certainly a lot of questions are arising in the context of certain corporate transactions. So that's one development we've seen in the UK in that space. If we can move on to the next slide, just a brief summary of what we have seen. So in December 2021, the UK government announced a package of certain new export control measures. Firstly, there was an update to the strategic export licensing criteria. So that's the criteria against which the UK government will assess export licenses. Again, this was more of an incremental development. There was a bit more of a focus on human rights, terrorist end uses, for example. The framework remains largely the same, and the sensitivities remain largely the same as well. So aligned with the US team's updates, we're seeing a lot of focus and sensitivity for obvious reasons on Russia, also Belarus, and also China at the moment. So there's a number of sensitivities, and we'll talk tomorrow about some of the good seizures we've been seeing in the UK with respect to Russia, both outbound and inbound through UK customs. Separate to the dual use licensing framework, we also have a bit of an enhancement to the UK's military and use control. So if we advance on to the next slide, we saw that announced in December, and then in April this year, we saw the changes come through, effectively expanding this military and use control. So this is one of the so-called catch-all controls. So even if you don't have a controlled item, there are certain sensitive end uses where you may require a license in order to proceed with an export. So historically, the focus has been on items where there's been knowledge or awareness of a military end use, so goods used in connection with the development, production, or incorporation into military items, for example. The enhancement here has expanded that military end use control such that where an exporter is informed, and so it's specifically informed and not aware, which narrows it slightly. But if they're informed of a relevant entity as end user, so that is an entity which is military, paramilitary, and the police forces, security services, or intelligence services. So there's a bit of an expansion there, and puts further pressure on exporters' due diligence systems to identify any potential end uses in that space. And if we flip on to the next slide, there's a couple of other important points. One key point is the UK has updated its list of embargoed destination where this control applies. So it only applies in respect of certain embargoed destinations, but China, Hong Kong, and Macau have all been added to the list of UK embargoed destinations in the UK export control order. So in line with the significant export focus on China as a destination at the moment. On top of that, there's been certain exceptions for this new dual use, military and use control around consumer goods, certain mass market software, technology, and medical goods. And as with all UK export controls, and we'll talk more about enforcement tomorrow, offences can be of a strict liability nature. So it doesn't need to have knowledge or suspicion. There is that informed element in respect of this new military and use control, but UK export controls can bite even on a strict liability basis. If we advance to the next slide, please. Another development, there has been certain incremental developments on the UK side with respect to certain open general export licenses, certain licenses where Russia's been removed, for example, but one slight expansion in lieu of some meetings and statements around greater cooperation between the UK and India. We've seen a couple of new OJLs come in, giving a bit more flexibility for the export of certain dual-use items and certain military goods and technology to India. As always, with these off-the-shelf open general export licenses, it's really important to understand the scope, which items are in scope, and comply with all terms and conditions, including record keeping and reporting requirements. And then if we can move on to the next slide, and the final one on the UK, we'll talk a bit more about enforcement tomorrow. It is an area where the UK authorities have been a bit more active in recent times. There's been quite a significant export penalty imposed. We'll talk about it in tomorrow's session. We are seeing increased activity as well from the Export Control Joint Unit. So that's the body in the UK responsible for the administration and licensing in respect of export controls. We're still seeing heavy use of audits by the export authorities, and we're also seeing an uptick in goods being seized at the border, and particularly UK Border Force and companies engaging with Border Force in respect to the release of certain items. And this all comes from UK enforcement statistics. There are some useful statistics. As a reminder, whenever you're exporting from the UK, if you're wondering how sensitive that export is, there is a bank of statistics you can check as to how many exports have been allowed or refused to that particular destination of that particular export control classification item. So that's on a recap on the UK side. If we move on now to the EU side, if we move on to the next slide, and I'll bring in Paul in a second as well, who can build on what Kerry was saying around the cooperation between the US and the EU and the move potentially to more a multilateral approach to export controls, but dealing with some again of the incremental changes. So we've covered this before, it's not new, but as I've mentioned, the EU dual use regulation was effectively replaced, it was recast, and that came into effect on the 9th of September last year and did bring in some material changes. The changes weren't quite as broad as had been anticipated. There was a lot of pushback from industry around some of the due diligence requirements, around the breadth of the human rights and use control and some of the cyber surveillance controls. But we have seen some material changes come in. In the last few months, we've seen exporters grapple and ensure compliance with those controls. That has included a greater focus on cyber surveillance technologies, similar to the summary Kerry gave earlier. It's seen some expanded EU licenses. So we've seen a lot of registrations, both in the UK post-Brexit, but also in the EU to comply with and register and use new EU dual-use export licenses. But the new dual-use regulations there, exporters are complying with it, and there are a number of advancements that have come in that we've covered in previous sessions. In terms of more recently, if we move on to the next slide, one of the key tenets brought in by the incrementally enhanced dual use regulation is a greater focus on due diligence. And this is something we're also seeing in certain proposals with respect to supply chain due diligence. So it really is putting pressure on export compliance programs, policies and procedures, and within that, particularly due diligence procedures. We've also, as we've got on this side, seen a lot of focus on due diligence and the use of contract clauses being referenced in EU guidance related to the Russia sanctions. So there are increased expectations around due diligence programs for exporters. In some cases, you need to demonstrate you have due diligence programs and internal compliance programs of a sufficient breadth in place to obtain certain types of export licenses. And there are references in there to requirements on exporters to have a focus on effective, appropriate, and proportionate policies and procedures. And if we move on to the next slide, again, it's a slide we've shown previously, but it does bring out some of the crossover between the EU, the UK, the US, and many other export and other compliance regimes, some fundamental principles underpinning the EU guidance on internal compliance programs and the US and UK equivalent guidance, and similar guidance issued by other member states as well. Germany in particular has been active in issuing guidance on expectations in terms of trade compliance control programs. But yeah, similar themes in terms of having a commitment to compliance from the very top, effective risk assessments, policies, procedures, setting the standards and controls, effective training and communication to staff and business partners, and effective monitoring, auditing, and responding to issues. So some familiar themes there, and we've seen a lot of focus in the last few months in light of the new EU recast dual use regulation on exporters ensuring they have adequate programs in place for export controls, likewise for sanctions and other broader financial crime areas. So a bit of recap on some of the developments and the focus on due diligence. If we move on to the next slide, we have seen again some incremental enhancements. So the EU updated its dual use list, broadly bringing it in line with some relatively minor this time round changes to bring those controls in line with international updates. The EU has had for some time those controls that Alex was talking about in terms of certain IP network surveillance or intrusion software related items, but some incremental enhancements were made in January this year. As I mentioned, we've seen Russia, both in the UK and EU, removed from certain open general export licenses, given the increased sensitivities. And we've seen certain logistical changes come through with the new EU framework as well. So some changes around the codes that have to be referenced to meet record keeping and export declaration requirements. So some new export declaration codes on customs forms have come in as well. So a lot of changes, more incremental, as I mentioned, in the last 6 months or so. And I'll bring in Paul now to give a bit of a recap and build on what Kerry was talking about, the partnership between the EU and the US.
Thanks, Ben. Yeah, just to wrap up here, I mean, Kerry was mentioning the EU-US, depending on which side of the pond you're on, whichever comes first, Trade and Technology Council. This was something that was established, as many of you all know, last summer in June, and has now celebrated second ministerial back in May. Those processes are really more consultative, higher level type sessions, but the Trade and Technology Council also has several working groups that are more sort of the working group level to really hash out what sorts of initiatives and controls, et cetera, that we want to push for at an EU and US bilateral level here. One of those working groups is one indeed focused on export controls. And I think just yesterday, there was a follow-up meeting held on for this working group. So the way it works just operationally, in case you are interested in having input into the process, at least from a US side, there will be a Federal Register notice published requesting comment. So you can submit comments that would be brought to this working group, or indeed solicit the ability to participate in the working group and attend the sessions, because they are very interested in having stakeholder input as they try to sort through what could become a new important avenue for implementing new export controls, or at least driving a separate multilateral process, given the potential challenges of ongoing control through or sort of updating controls vis-a-vis the Wassenaar process, which I think, Ben, as you can recollect, I mean, it usually takes a long time, even in the best of circumstances, for the Wassenaar arrangement changes to be implemented in the EU, for example. So perhaps this is a way in which changes can be made more quickly, and if not unilaterally, somewhat less multilaterally, and focusing on the key geopolitical issues that both EU and US stakeholders share concerns with. So I think that stakeholders should look to participate in this process, because I do think it will become an important vehicle for new and emerging controls going forward. Back to you, Allison.
Ben, or Paul, there is one question in the chat regarding the EU approach to Belarus. As you know, on the US side, the US has aligned the EAR controls for both Russia and Belarus to match. How about on the EU side?
Yeah, so I think that development in the EU for Russia was born out of the fact that Russia featured in a number of the different EU general export authorizations, whereas Belarus has not. I think there's maybe one Belarus was on, but we're certainly seeing the same sensitivity for Belarus. And we'll talk tomorrow about the Russia and Belarus product controls, but we've seen both the UK and EU effectively ban the export of dual-use items to Belarus and Russia, but for very limited licensing grounds and situations and exemptions. That includes broad restrictions on encryption control. So there's a lot of sensitivity around Belarus, not least given the risk of diversion to Russia, but also in its own right, reflecting the EU and UK sanctions on Belarus.
Great, thanks very much. Well, thank you to all our panelists today for that whirlwind tour of export control developments. John, if I may hand it back to you to give us a preview of what's next.
Thank you, Allison, and my thanks as well to each of Ben, Paul, Carrie, and Alex for terrific contributions. So thank you all very much. By way of evaluation of the program, please note that when you terminate the webinar and leave the webinar, there will be a program evaluation form. We very much welcome your comments and invite you to provide the good, bad, and the ugly to help us deliver better programs going forward. This brings us to the end of this particular session. As I said at the outset, we have a series of additional sessions as part of this program. I hope you will join us in a little bit more than 2 hours, 12 o'clock noon Pacific time, and about 2 hours hence, wherever you may be, where we'll be talking about customs and import developments, US, Canada, EU, and UK. So I certainly hope you'll be with us for that session. With that, again, my thanks, and let's adjourn for the time being.